A bilateral meeting between President Trump and President Zelensky was planned for September 1 in Warsaw. The same Warsaw meeting we were just discussing, without the Ukrainians saying a word about investigations. As it turned out, President Trump was not able to attend the meeting in Warsaw because of Hurricane Dorian. President Trump asked Vice President Pence to attend in his place. But even that scheduling glitch did not put off their meeting for long. President Trump and President Zelensky met at the next available date, September 25, on the sidelines of the United Nations General Assembly. As President Zelensky himself has said, there were no preconditions for his meeting with President Trump. Those are his words, no conditions. So, you're probably wondering, how could the House managers claim that there was a quid pro quo for a meeting with President Trump when the two presidents actually did meet without President Zelensky announcing any investigations? Well, the House managers moved the goalposts again. They claimed that the meeting couldn't be just an in-person meeting with President Trump. What it had to be was a meeting at the Oval Office and in the White House. That's nonsense. Putting to one side the absurdity of the House managers trying to remove a duly elected President of the United States from office because he met a world leader in one location versus another, this theory has no basis in fact. As Dr. Hill testified, what mattered was that there was a bilateral presidential meeting, not the location of the meeting. She said, it wasn't always a White House meeting per se, but definitely a presidential level, meeting with Zelensky and the president. I mean, it could have taken place in Poland, in Warsaw. It could have been, a proper bilateral in some other context, but in other words, a White House level presidential meeting. The House managers didn't tell you about Dr. Hill's testimony. Why not? In fact, they said just last week that President Zelensky still hasn't gotten his White House meeting. Why didn't they tell you about Dr. Hill's testimony? So you would have the full context and information. They spoke for over 21 hours. They couldn't take a couple of minutes to give you that context? How else do we know that Dr. Hill was right? Because President Zelensky said so on the July 25 call. Remember, when President Trump invited President Zelensky to Washington on the July 25 call, President Zelensky said he would be happy to meet with you personally and offered to host President Trump in Ukraine, or, on the other hand, meet with President Trump on September 1 in Poland. That's exactly what the administration planned to do. If it weren't for Hurricane Dorian, President Trump would have met with President Zelensky in Poland on September 1, just as President Zelensky had requested, and without any preconditions. As it happened, President Zelensky met with the Vice President instead, and just a few weeks later, met with President Trump in New York, all without anyone making any statement about any investigations. And once again, not a single witness in the House record that they compiled and developed under their procedures that we've discussed and will continue to discuss provided any firsthand evidence that the President ever linked a presidential meeting to any investigations. The House managers have seized upon Ambassador Sondland's claim that Mr. Giuliani's requests were a quid pro quo for arranging a White House visit for President Zelensky. But again, Ambassador Sondland was only guessing based on incomplete information. He testified that the President never told him that there was any sort of a condition for a meeting with President Zelensky. Why then did he think there was one? In his own words, Ambassador Sondland said that he could only repeat what he heard through Ambassador Volker from Giuliani. so he didn't even hear from Mr. Giuliani himself. But Ambassador Volker, who is the supposed link between Mr. Giuliani and Ambassador Sondland, thought no such thing. Ambassador Volker testified unequivocally that there was no linkage between the meeting with President Zelensky and Ukrainian investigations. I'm going to read the full questions and answers because this passage is key. This is from Ambassador Volker's deposition testimony. Question: did President Trump ever withhold a meeting with President Zelensky or delay a meeting with President Zelensky until the Ukrainians committed to investigate the allegations that you just described concerning the 2016 presidential election? Answer: the answer to the question is no, if you want a yes or no answer, but the reason the answer is no is we did have difficulty scheduling a meeting, but there was no linkage like that. Question: you said that you were not aware of any linkage between the delay in the Oval Office meeting between President Trump and President Zelensky and the Ukrainian commitment to investigate the two allegations as you described them, correct? Answer: correct. On no fewer than 15 separate occasions over the past week, the House managers played a video of Ambassador Sondland saying that the announcement of the investigations was a prerequisite for a meeting or call with the president. 15 times. They never once read to you the testimony that I just did. They never once read to you the testimony in which Ambassador Volker refuted what Ambassador Sondland claimed he heard from Ambassador Volker. So here's what we know. President Trump invited President Zelensky to meet 3 times without preconditions. The White House was working behind the scenes to schedule the meeting. The two presidents planned to meet in Warsaw, just as President Zelensky had asked, and ultimately met 3 weeks later without Ukraine announcing any investigations. No one testified in the House record that the president ever said there was a connection between a meeting and investigations. Those are the facts, plain and simple. So much for a quid pro quo for a meeting with the president. Before I move on, let me take a brief moment to address a side allegation that was raised in the original whistleblower complaint and that the House managers are still trying to push. The managers claim that President Trump ordered Vice President Pence not to attend President Zelensky's inauguration in favor of a lower-ranking delegation, in order, according to them, to signal a downgrading of the relationship between the United States and Ukraine. That's not true. Numerous factors had to align, as I'm sure everyone in this room can greatly appreciate, for the Vice President to attend. First, dates of travel were limited. For national security reasons, the President and Vice President generally avoid being out of the country at the same time for more than a few hours. The President had scheduled trips to Europe and Japan during the period when our embassy in Ukraine anticipated the Ukrainian inauguration would occur at the end of May or in early June. Jennifer Williams testified that the Office of the Vice President advised the Ukrainians that if the Vice President were to participate in the inauguration, the ideal dates would be around May 29, May 30, May 31, or June 1, when the President would be in the United States. She said, if it wasn't one of those dates, it would be very difficult or impossible for the Vice President to attend. Second, the House managers act as if no other priorities in the world could compete for the administration's time. The Vice President's office was simultaneously planning a competing trip for May 30 in Ottawa, Canada, to participate in an event supporting passage of the United States-Mexico-Canada agreement. Ultimately, the Vice President traveled to Ottawa on May 30 to meet with Prime Minister Justin Trudeau and to promote the passage of the USMCA. This decision, as you know, advanced a top administration priority and an issue President Trump vigorously supported. What you did not hear from the House managers was that the Ukrainian inauguration dates did not go as planned. On May 16, the Ukrainians surprised everyone and scheduled the inauguration for just 4 days later, on May 20, Monday, May 20. So think about that. May 16, May 20. Get everybody, security, advance, everyone to Ukraine. Jennifer Williams testified that it was very short notice, so it would have been difficult for the Vice President to attend, particularly since they hadn't sent out the advance team. George Kent testified that the short notice left almost no time for either proper preparations or foreign delegations to visit, and that the State Department scrambled on Friday the 17th to try and figure out who was available. Mr. Kent suggested that Secretary of Energy Perry be the anchor for the delegation as someone who is a person of stature and whose job had relevance to our agenda. Secretary Perry led the delegation, which also included Ambassador Sondland, Ambassador Volker, and Senator Johnson. Ambassador Volker testified that it was the largest delegation from any country there, and it was a high-level one. The House managers didn't tell you this. Why not? The claim that the President instructed the Vice President not to attend President Zelensky's inauguration is based on House manager assumptions with no evidence that the President did something wrong. And finally, as I'm coming to the end, if the evidence doesn't show a quid pro quo, what does it show? Unfortunately for the House managers, one of the few things that all of the witnesses agreed on was that President Trump has strengthened the relationship between the U.S. and Ukraine, and that he has been a more stalwart friend to Ukraine and a more fierce opponent of Russian aggression than President Obama. The House managers repeatedly claimed that President Trump doesn't care about Ukraine. They are attributing views to President Trump that are contrary to his actions. More importantly, they are contrary to the House managers' own evidence. But don't take my word for it. Ambassadors Yovanovitch, Taylor, and Volker all testified to the Trump administration's positive new policy toward Ukraine based especially on President Trump's decision to provide lethal aid to Ukraine. Ambassador Taylor testified that President Trump's policy toward Ukraine was a substantial improvement over President Obama's policy. Ambassador Volker agreed that America's policy towards Ukraine has been strengthened under President Trump, whom he credited with approving each of the decisions made along the way. Ambassador Yovanovitch testified that President Trump's decision to provide lethal weapons to Ukraine meant that our policy actually got stronger over the last 3 years. She called the policy shift that President Trump directed very significant. Let's hear from Ambassador Taylor, Ambassador Volker, and Ambassador Yovanovitch.
The Trump administration has indeed provided substantial aid to Ukraine in the form of defensive lethal aid, correct?
That is correct.
And that is more so than the Obama administration, correct?
The Trump
defensive lethal aid.
Yes.
President Trump approved each of the decisions made along the way, providing lethal defensive equipment.
And the Trump administration strengthened our policy by approving the provision to Ukraine of anti-tank missiles known as Javelins. They are obviously tank busters, and so if the war with Russia all of a sudden accelerated in some way and tanks come over the horizon, Javelins are a very serious weapon to deal with that.
Ukraine is better positioned to fight Russia today than it was before President Trump took office. As a result, the United States is safer too. The House managers did not tell you about this testimony from Ambassadors Taylor, Volker, and Yovanovitch. Why not? These are the facts, as drawn from the House managers' own record on which they impeached the president. This is why the House managers' first article of impeachment must fail, for the 6 reasons I set forth when I began on Saturday. There was no linkage between investigations and security assistance or a meeting on the July 25 call. The Ukrainians said there was no quid pro quo, and they felt no pressure. The top Ukrainians did not even know that security assistance was paused until more than a month after the July 25 call. The House manager's record reflects that anyone who spoke with the president said that the president made clear that there was no linkage. The security assistance flowed and the presidential meeting took place, all without any announcement of investigations, and President Trump has enhanced America's support for Ukraine in his 3 years in office. These facts all require that the first article of impeachment fail. You have already heard and will continue to hear from my colleagues on why the second article must fail. Once again, this is the case that the House managers chose to bring. This is the evidence they brought before the Senate. The very heavy burden of proof rests with them. They say their case is overwhelming and uncontested. It is not. They say they have proven each of the articles against President Trump. They have not. The facts and evidence of the case the House managers have brought exonerate the president. Thank you for your attention, and I think we're ready for a break.
The Majority Leader is recognized.
Justice, colleagues will take a 15-minute break.
Without objection.
All right, the president's lawyers going about 2 hours in 2 very specific lines of arguments. One, the constitutionality of this impeachment under these circumstances. And then you heard in that last half hour or so, really trying to peel back some of the evidence that they say the House managers didn't bring forward. As just a point of fact-checking, however, it's fair to keep in mind that it's all being pulled from the transcripts and from what was live public testimony. And how the sides carve it up, that's another question. We've got Chuck Rosenberg here, a former federal prosecutor. We've got Barrett Berger, also a former federal prosecutor, NBC News legal analyst, Andrea Mitchell. Chuck Todd is in Washington. Let's break it down a little bit. First of all, Barrett, the arguments that they've brought forward so far, how do they play?
Well, I think they're working with what they have. I mean, I thought Ken Starr's arguments to start off the day were interesting, to say the least. I mean, sort of boiled down to its essential core. He was arguing that we've had too many impeachments and that we're making it too easy to go about this process, which, aside from sort of the ironic nature of this coming from Ken Starr, it really just isn't borne out by the facts. I mean, we really have only had in the last 20 years, you know, 1 presidential impeachment of Donald Trump and 2 judicial impeachments. So we have not seen sort of the floodgates opening and, you know, an impeachment every year. It is still a measured process. So it was an interesting way to start this this day.
Chuck, what were your thoughts here in this this testimony so far, this presentation?
Yeah, this is much of what you would expect to hear from defense attorneys. Barrett knows this better than anybody. They don't have that much to work with, and so they've tried to highlight things that the impeachment managers omitted. They keep asking sort of rhetorical questions. Why didn't they tell you this? Or wouldn't you have liked to have known that? That's fairly standard. But the main thrust of the House impeachment argument, I think, remains intact. I don't think they've really done very much to undermine the basic facts of the case, which, Lester, are quite strong.
Yeah. And Andrea, one thing that was dispensed with rather quickly by Jay Sekulow in the first 20 seconds or so, they're not going to talk about John Bolton and this New York Times reporting that his book manuscript says there was in fact a quid pro quo, that the president did attach conditions to aid to Ukraine.
He referred to it in his opening sentences as speculation. Well, it is not speculation. It is widely reported, according to multiple sources, and the Bolton attorneys say that it came from the White House. It came precisely from the National Security Council reviewers, who have to, by law and regulation, review every book that is published by someone who had classification and dealt with secrets, and that there were no secrets involved that were going to be removed, but that it came from them, that it did not, they assert, come from Bolton, his lawyers, his publisher. And they, in this book, Bolton writes, he was in the room, it's called In the Room Where It Happened, taking from, of course, the widely popular Hamilton play, and saying that he was there and that the president directly linked withholding the aid to Zelensky, the president of Ukraine, the new president, investigating the Bidens. Yeah. And that is essentially the core of this. Then, of course, the attorney Purpura cherry-picked, if you will, that July 25th call and ignored all of the other evidence that did directly, aside from Bolton, but that did, Sondland and others, say that there was a quid pro quo.
Let me bring Chuck Todd in the conversation. Chuck, if there was ever an elephant in the room, this was it. Are you surprised that they're not taking this on directly?
Oh, I think they are, though, taking it on. Listen to that sentence. Listen to one of the lines that was right near the end, where one of the president's attorneys, and I think it was Mr. Purpura there, said, this is the evidence they brought before the Senate. They also stuck by, Jay Sekulow stuck by the idea that they have not presented evidence that has the president directly linking the president to this. So they're essentially sticking by their story that they have. And it appears to me then they're going to make an appeal on the witness front, as far as the Republicans are concerned, like, once again to say the Democrats had a chance to do this, they chose not to. Your job is to review the evidence that they brought forward. I do think, though, going down this line, I think I don't think this is going to be an easy way for them to convince anybody on the fence about witnesses that they don't need witnesses. So I don't think it's helpful, but it's clear to me they're trying to address the Bolton situation. Can I just make, Barrett, I thought you were being very deferential or diplomatic on the Ken Starr thing. I'll say it less diplomatically. This is akin to a bank robber complaining that banks were too easy to rob.
I'd say that's less diplomatically. What do you say, Barrett?
She's an attorney.
Astonished. It is astonishing that Ken Starr is lamenting that it's become too easy to use impeachment, when, by any measure, the Clinton impeachment is something that a lot of people have debated left and right about. Did it sort of define impeachment downward? That is the impeachment. It isn't like the others. And so to then use that impeachment, have Ken Starr, the sort of architect of it, make the case that, you know, oh, man, we're having impeachments every 20 years now. And you're like, well, wait a minute. I do think they could have found, I think the argument would have been more legitimate had they not had Ken Starr making the argument.
I'm sorry, Chuck, someone was in my ear there. Thank you for your point. I'm sorry, what's happening in the...
More honest.
Okay, we're hearing a couple of the Republican senators now are speaking. Here we go.
When we were in our own conference today at lunch, we're going to cross that bridge when we get to it on Thursday or Friday. And I think every senator will have a different opinion. You heard a little bit of that today in lunch.
Do you want to see this?
You know, go ahead.
But I would say what I saw today was really a strong discussion of the role of the Constitution and the role of impeachment in the country, and what happens when impeachment becomes partisan and when impeachment is used as a political weapon. You know, what we also heard after that discussion was the fact that the president has a right and a responsibility to fight corruption, especially when it involves taxpayer money, and how he has continued to do that as any president should. On Friday, standing here, I said, hey, there's going to be new revelations every day, and there certainly was one in the New York Times released last night, and the paper tomorrow. I don't know what we're going to see, but there'll be something new as people are out there trying to inflame emotions and influence decisions that are being made. So you see information leaked from a book. To me, it's nothing new than charges that have been made by other people already. The voting is starting in Iowa in a week. The Democrats are trying to remove the president from the ballot. I go home to Wyoming, I talk to people, they say, let the voters make that decision.
Aren't the documents a way to take the partisanship out?
What John Bolton said, that the president...
All right, hearing some of the Republican view, trying to downplay that New York Times reporting about John Bolton and what he has apparently put in the manuscript of his book, saying, in fact, there was a quid pro quo, that the president had linked Ukraine aid, and of course, that's circulating around the Hill right now. We're going to go to Casey Hunt in a moment, but I think we have Senator Elizabeth Warren is joining us right now. Senator, good to see you.
It's good to see you, too.
I'm sorry, I'm like traffic cop here trying to get everybody in line, but it is good to have you here. Tell me how you think the mood has changed, or has it not changed, in terms of members of the Senate who are listening now and now have this knowledge of what apparently is in John Bolton's manuscript?
Yeah, well, I think the heat has turned up now under the Republicans. I have to say, I was really shocked that at least twice today, while we're sitting in that first 2 hours, is that we heard the president's lawyers assert, hey, you've got no one who directly links the president with any kind of quid pro quo. It's all inference, and there are other reasons to explain all this. And, you know, it's like you want to hold a big sign up saying, where are the witnesses? Where's John Bolton? And, you know, at least according to the reports, Bolton says not only did he hear it, he indicates that Secretary Pompeo and Attorney General Barr also somehow have information about this. You know, this has been the problem from the beginning. It's a trial in the Senate. That's what the Constitution requires. I don't know how anybody does a trial when you don't call witnesses and you don't bring in any documents.
Well, but back to my question, are you sensing any change of mood? Now, we heard a couple of Republican senators right there seem like they're totally unmoved in this issue. But do you think this will have an effect as the next couple of days wear on?
As I said, I think what it is about turning up the heat, and I think Republicans are getting increasingly unhappy with the position that they are forced into. When the president's lawyers are arguing nobody can link Trump directly to this, and John Bolton's book is saying he can link Trump directly, and both of those are happening at the same time, that just puts Republicans in a position where they just have to stand up and say, we have to have those witnesses in, or they have to admit their whole case is based only on blocking evidence. There's no truth in any part of it.
Senator, my colleagues Chuck Todd and Andrew Mitchell are both here. I think they have questions for you, Chuck.
Sure.
Senator Warren, are you comfortable with the fact that on caucus night you may be right where you are right now, on the floor of the Senate? The results could get announced, and you've got to be listening to witness testimony. You know, I know your day job is your day job. Are you prepared for that outcome?
Yes, I am. Yeah, I took an oath to uphold the Constitution of the United States, and that Constitution says no one is above the law. An impeachment trial is the way the Senate enforces that part of the Constitution. So I took an oath, I'll be here.
And if it impacts your campaign, it impacts your campaign.
Some things are more important than politics, but I will say this. I'm really glad and really grateful that the kind of grassroots team that we've built on the ground in Iowa and grassroots supporters around the country have really jumped in and said, we understand you can't be there. We'll make phone calls, we'll knock on doors, we'll redouble our efforts, and I'm very grateful for that. But at the end of the day, I got to be here.
Senator, while you're there, and if there are no witnesses, if you don't win this argument, and even the Bolton revelations don't turn that in the Democrats' favor, would you consider a fallback plan, which I've heard discussed among a number of your colleagues, which says that if you're not going to get 67 votes, which you're clearly not about to get, and have him convicted and taken out of office, and if people are making the argument that even among some Democrats that is too severe and that the election is in play, would you consider something like a censure as a way of saying to the president, from your perspective, what you did was not right, you were not really found to be not guilty, and that at least there is some measure of criticism and punishment?
Look, we're in a trial right now, and I think that's where we absolutely have to stay focused. I don't think this is about trying to negotiate around that trial. We are supposed to have a fair trial in the United States Senate. That is the solemnity of this occasion. And you don't have a fair trial without witnesses. That's just where we've got to be. And by the way, I just want to add one more part. Every time the Republicans say, oh, you're just trying to overturn the election, wait and let voters determine this in November, and that that was a big part of Ken Starr's argument. Keep in mind, no one is going after the president for many other forms of corruption. The ambassador who lies at the heart of this, who paid $1 million in order to get nominated as an ambassador, and so on and so on and so on. This is about interference in an election, and that really is the heart of what this is about. If the president can actually get a foreign country to interfere in our election, what does that mean as we head into November? That's why this issue is so important. And the fact that the president has been able to throw up a fence and say you're not going to get to talk to any of the witnesses, you're not going to get to talk to any of the see any of the documents, and right now the Republicans are supporting them. It means that he himself and the Republicans are undermining the upcoming election. Well, it's just an argument that doesn't hold.
Senator Elizabeth Warren, I know this is a short break, and you probably want to grab something to eat, so we'll let you go. But thank you for stopping by our cameras here.
Thank you.
All right, let's go to Casey Hunt, who is also at the Capitol. You're getting some of the hallway conversation back and forth. What are you hearing?
Well, Lester, I think we've gotten a sense already of the Republican strategy here among the senators for dealing with this big bombshell revelation in the New York Times, which is they're determined to basically put it off until the end of the week to see how this plays out. They're all starting to say that during the lunch that they had, they decided, you know what, we'll answer this question on Thursday or Friday after we've heard the White House defense. Now, what does that potentially do from a political perspective? It may diffuse the issue or the urgency around it. However, it does seem clear to me that there is some additional pressure behind the scenes. So I think there's an element of back and forth between the leadership and some of the more conservative Republicans in the conference to those who may be open to voting for witnesses. And you and I were talking a little bit about this earlier. We have those usual suspects, Susan Collins, Mitt Romney, Lisa Murkowski. The big question here is whether there's a group of more traditional Republican senators who don't feel that this explanation is good enough. And Lester, one Democratic senator came out of the chamber and called this White House defense surreal. They really are talking past this Bolton news that everyone else is talking about. You correctly noted they didn't talk about Bolton on the floor. And if you think about what his book, his manuscript says in the context of this defense that the White House has been making, it becomes pretty clear the stark difference. And we've seen one of the lawyers for the House managers, Dan Goldman, speaking to reporters upstairs, seeming agitated and angry, accusing the White House defense of essentially misleading the jury by leaving out critical facts. So, you know, they're essentially arguing that the president had other reasons for this pause, that there was no quid pro quo, that the evidence that the House has presented so far doesn't show it. But now we have a firsthand witness who is saying that there is contrary information to all of that. And, you know, that's a lot for Republicans to grapple with. And you already heard, of course, John Barrasso, who our viewers just saw a few moments ago. He's a member of Republican leadership. He said that there is, quote, nothing new than to the charges that people have already made. I think that it's clear that Bolton has added something new to this conversation, Lester.
All right, thanks for that, Casey. Let's go to the White House now. Kristen Welker. Kristen, how are they receiving all this?
Well, Lester, we are learning that according to a source close to the White House, the news of the Bolton book went off like a grenade for some folks here. And now we are learning that they are increasingly gearing up to prepare to essentially fight a potential Bolton subpoena. Now, that is something that, of course, President Trump signaled himself last week when he was traveling in Davos and he was asked if John Bolton should testify. And he said, look, it might be a national security issue if John Bolton testifies, but then he went even further to say that Bolton did not leave on good terms. One administration official telling me, look, we are preparing for all contingencies. So you can tell that something is shifting here within the administration. Again, they are gearing up for what will be a bigger fight, they think, at this point. President Trump has remained defiant throughout the day. He was asked about the revelations that were reported first in the New York Times about the Bolton book. President Trump calling them false. And then he took to Twitter and said this, Lester. He said, quote, John Bolton, I never told him that the aid to Ukraine was tied to investigations into Democrats, including the Bidens. In fact, he never complained about this at the time of his very public termination. If John Bolton said this, it was only to sell a book. So that is the messaging that we are hearing from President Trump. And in terms of strategy, I wouldn't be surprised, Lester, if you saw not only the president, but other administration officials here try to effectively discredit John Bolton, to try to paint him as a disgruntled former employee. But what is clear is that they are gearing up for a big fight here. President Trump, for his part, also focused on the counter-programming. He earlier today was meeting with Prime Minister Benjamin Netanyahu of Israel and Benny Gantz. Lester.
All right, Kristen, thank you very much. Pete Williams, our justice correspondent. Let me pick up on something Kristen talked about there, the White House efforts that could come to try and stop Bolton testimony to fight a subpoena. What sort of ammo do they legally have?
Not as much as they would have if he were a current administration employee and didn't want to testify. Normally, when we see these fights, Congress wants something, the president and the cabinet secretary don't want to give it to them, and Congress has to go to court to force them to come up. This is just the opposite. Here, the White House would be trying to stop something that John Bolton said he's already willing to do. So here's the process, Lester. This White House presentation will continue today and tomorrow. Then, under the rules that the Senate adopted when this whole trial began, there'll be 2 days probably of questions from both sides to the House managers and the White House lawyers. And then, probably maybe late Thursday, Friday, the Senate would finally getting around to vote on whether to call any witnesses. And under the rules the Senate adopted, if they do decide to call witnesses, they would subpoena the witness, and the rules say the witnesses must first be deposed. In other words, probably a committee of senators would meet them, both sides would ask questions of them, and then the full Senate would decide whether to hear either bits of that testimony or even have the person testify on the Senate floor. Now, that was not done during the Clinton impeachment, but it was done in the Andrew Johnson impeachment. There were many witnesses who testified on the Senate floor. So back to the answer to your question, the White House has a much taller order trying to stop someone who's not in the government, who is willing to testify, than it would have if it was somebody in the government who doesn't want to testify. It makes a much bigger burden for the White House to try to stop it.
All right, Pete, thanks very much. The lawyers of the president have got about 20 hours, or about 4 hours. They've got about 20 hours ahead of them if they wish. And that means the House managers are essentially an audience right now, and their chance to talk is in the hallways. And that's where Chuck Schumer was interviewed by my colleague Hallie Jackson just a few minutes ago. Let's hear what he had to say.
Hallie from NBC. You say you want Bolton. You obviously cannot do it alone. Do you believe that the book manuscript revelations that have come out are enough to get Republicans over the line? Is this a game changer?
Look, it's a little bit in this sense like Watergate. Every week, new evidence comes out that is further condemning of the president. And so, obviously, the revelations in the New York Times about the Bolton book strengthen the case for witnesses, for documents, even more. Each few days, something comes out, and the average American is saying, why don't they want witnesses and documents? And, you know, you can sit and listen to all these arguments, but one question looms overhead. If the president did nothing wrong, why is he so afraid of having witnesses and having documents?
Chuck Schumer speaking to reporters a few minutes ago in the hallway. Let me bring back Chuck Rosenberg. We've got the Chief Justice of the Supreme Court right there, as Adam Schiff has pointed out. At some point, could they turn these questions over to him, witnesses, subpoenas?
They absolutely could. But there's an important distinction here. When a federal judge is sitting in a federal courtroom, right, she's in charge, right? She makes the rules, and when she issues an order, litigants obey it. When the Chief Justice is sitting in the Senate, of course he's still a Chief Justice, but he's not really acting as a judge per se. He's presiding over the Senate. He's taking the place of the Vice President. He can make rulings, but he doesn't have the power to order the Senate to do whatever he wants them to do. In fact, the Senate very simply can override the vote or the ruling of a Chief Justice. So think of him more as a presiding parliamentarian than as a federal judge.
So he could rule yes witnesses and they could turn around and overrule him.
In fact, that's exactly what happened in the impeachment trial of Andrew Johnson. At the time, the Chief Justice of the United States was a gentleman named Salmon Chase. The first two orders he issued, and I use the term orders sort of lightly because really it's not an order, he can't enforce it, were overturned by majority votes to the Senate. That could happen to Chief Justice Roberts just as easily.
Pete Williams, you want to get into this?
Yeah, exactly right. I mean, it's not a legal proceeding, so he doesn't make legal rulings. The rules say he can rule on evidentiary issues and so forth, but that the Senate can immediately overrule him by a full vote. And for that reason, I would suspect that John Roberts will do what William Rehnquist did during the Clinton trial and just say, all right, here's this question. How do you want to decide it, rather than ruling first? He has that option. He can rule first and see if the Senate overrules him, or he can wait and just pitch it to the full Senate. I will say there is one very curious thing about that process, though. And think about this. A 50-50 vote would fail. So I don't think that, let's put aside this whole question about whether the Chief Justice breaks ties. He doesn't. A tie is a vote. It doesn't need to be broken. But here's the thing. Let's say a senator says, I want to call John Bolton as a witness. And if the Chief Justice says, okay, Senate, you vote on that, and the motion fails, no witness is called. Now let's take the same scenario. A senator says, I want to call witnesses. The Chief Justice says, okay, we'll call that witness, and then there's a vote, and that vote fails. Then witnesses will be called. So I'm sure the Chief Justice has thought about this. Even if it's a 50-50 vote, it fails. I doubt he's going to be an activist and make these calls on his own on such consequential questions. I think he's just going to say, this is your proceeding, you decide. So I agree with Chuck on that.
Yeah, and let me get Britt into the conversation here. Let's assume that for a moment that witnesses are allowed. It's more than John Bolton. And we mentioned there's going to be, you know, they have to be questioned ahead of time. The clock continues to run. How difficult is it to do a concise case when you've already made your arguments, and then you've got Q&A, then you bring in the witnesses? How difficult is it?
Well, it'll definitely extend the trial, but I don't think anyone should say, well, it's going to take so long, so we just shouldn't go through this process. I mean, I think this could be done on a fairly expedited basis. What this would require is for any witness, they'd need a lawyer, they'd need a little bit of time to prep, they'd have to be deposed, and then they could testify. This could be done in a matter of weeks. I don't think this is something that needs to be drawn out over months. We have seen in other cases witnesses come in and get this done very quickly. So I don't think it would extend it unreasonably.
All right, let's Jay Sekulow is back in front of the microphone as we get underway.
Over the last week, about one of our colleagues, former mayor of New York, Rudy Giuliani. Mayor Giuliani served as one of the leaders of the president's defense team during the Mueller investigation. He's mentioned 531 times, 20 in the brief and about 511, give or take, in the arguments, including the motion day. We had a robust team that worked on the president's defense during the Mueller probe. Consisted of Mayor Giuliani, Andrew Economou, Stuart Roth, Jordan Sekulow, Ben Cisney, and Mark Goldfeder. Mayor Giuliani, of course, and Marty Raskin, as well as Jane Raskin. Jane Serene Raskin was one of the leading attorneys on the Mueller investigation for the defense of the president. The issue of Mayor Giuliani has come up here in this chamber a lot. We thought it would be appropriate now to turn to that issue. The role of the president's lawyer, his private counsel, in this proceeding. I would like to yield my time, Mr. Chief Justice, to Jane Serene Raskin.
Mr. Chief Justice, Majority Leader McConnell, members of the Senate, I expect you have heard American poet Carl Sandburg's summary of the trial lawyer's dilemma. If the facts are against you, argue the law. If the law is against you, argue the facts. If the facts and the law are against you, pound the table and yell like hell. Well, we've heard the House managers do some table pounding and a little yelling. But in the main, they've used a different tactic here, a tactic familiar to trial lawyers, though not mentioned by Mr. Sandburg. If both the law and the facts are against you, present a distraction, emphasize a sensational fact, or perhaps a colorful and controversial public figure who appears on the scene, then distort certain facts, ignore others, even when they're the most probative, make conclusory statements, and insinuate the shiny object is far more important than the actual facts allow. In short, divert attention from the holes in your case. Rudy Giuliani is the House manager's colorful distraction. He's a household name, legendary federal prosecutor who took down the mafia, corrupt public officials, Wall Street racketeers, crime-busting mayor who cleaned up New York and turned it around, a national hero, America's mayor after 9/11, and after that, an internationally recognized expert on fighting corruption. To be sure, Mr. Giuliani has always been somewhat of a controversial figure for his hard-hitting, take-no-prisoner approach. But it's no stretch to say that he was respected by friend and foe alike for his intellect, his tenacity, his accomplishments, and his fierce loyalty to his causes and his country. And then, the unthinkable. He publicly supported the candidacy of President Trump, the one who was not supposed to win. And then, in the spring of 2018, he stood up to defend the president, successfully it turns out, against what we all now know as the real debunked conspiracy theory, that the Trump campaign colluded with Russia during the 2016 campaign. The House managers would have you believe that Mr. Giuliani is at the center of this controversy. They've anointed him the proxy villain of the tale, the leader of a rogue operation. Their presentations were filled with ad hominem attacks and name-calling. Cold-blooded political operative, political bagman. But I suggest to you that he's front and center in their narrative for one reason and one reason alone: to distract from the fact that the evidence does not support their claims. So what's the first tell that Mr. Giuliani's role in this may not be all that it's cracked up to be? They didn't subpoena him to testify. In fact, Mr. Schiff and his committee never even invited him to testify. They took a stab at subpoenaing his documents back in September, and when his lawyer responded with legal defenses to the production, the House walked away. But if Rudy Giuliani is everything they say he is, don't you think they would have subpoenaed and pursued his testimony? Ask yourselves, why didn't they? In fact, it appears the House committee wasn't particularly interested in presenting you with any direct evidence of what Mayor Giuliani did or why he did it. Instead, they ask you to rely on hearsay, speculation, and assumption, evidence that would be inadmissible in any court. For example, the House managers suggest that Mr. Giuliani, at the president's direction, demanded that Ukraine announce an investigation of the Bidens and Burisma before agreeing to a White House visit. They base that on a statement to that effect by Ambassador Sondland. But what the House managers don't tell you was that Sondland admitted he was speculating about that. He presumed that Mr. Giuliani's requests were intended as a condition for a White House visit. Even worse, his assumption was on third-hand information. As he put it, the most he could do is repeat what he heard through Ambassador Volker from Giuliani, whom he presumed spoke to the president on the issue. And by the way, as Mr. Purpura has explained, the person who was actually speaking to Mr. Giuliani, Ambassador Volker, testified clearly that there was no linkage between the meeting with President Zelensky and Ukrainian investigations. The House managers also make much of a May 23rd White House meeting during which the president suggested to his Ukraine working group including Ambassadors Volker and Sondland, that they should talk to Rudy. The managers told you that President Trump gave a directive and a demand that the group needed to work with Giuliani if they wanted him to agree with the Ukraine policy they were proposing. But those words, directive and demand, are misleading. They misrepresent what the witnesses actually said. Ambassador Volker testified that he understood, based on the meeting, that Giuliani was only one of several sources of information for the president. And the president simply wanted officials to speak to Mr. Giuliani because he knows all these things about Ukraine. As Volker put it, the president's comment was not an instruction, but just a comment. Ambassador Sondland agreed. He testified that he didn't take it as an order, and he added that the president wasn't even specific about what he wanted us to talk to Giuliani about. So, it may come as no surprise to you that after the May 23rd meeting, the one during which the House managers told you the president demanded that his Ukraine team talk to Giuliani, neither Volker nor Sondland even followed up with Mr. Giuliani until July. And the July follow-up by Mr. Volker happened only because the Ukrainian government asked to be put in touch with him. Volker testified that President Zelensky's senior aide, Andriy Yermak, approached him to ask to be connected to Mr. Giuliani. House Democrats also rely on testimony that Mayor Giuliani told Ambassadors Volker and Sondland that, in his view, to be credible, a Ukrainian statement on anti-corruption should specifically mention investigations into 2016 election interference and Burisma. But when Ambassador Volker was asked whether he knew if Giuliani was, and these are his words, conveying messages that President Trump wanted conveyed to the Ukrainians, Volker said that he did not have that impression. And he believed that Giuliani was doing his own communication about what he believed he was interested in. But even more significant than their reliance on presumptions, assumptions, and unsupported conclusions is the manager's failure to place in any fair context Mr. Giuliani's actual role in exploring Ukrainian corruption. To hear their presentation, you might think that Mayor Giuliani had parachuted into the president's orbit in the spring of 2019 for the express purpose of carrying out a political hit job. They'd have you believe that Mayor Giuliani was only there to dig up dirt against former Vice President Biden because he might be President Trump's rival in the 2020 election. Of course, Mr. Giuliani's intent is no small matter here. It's a central and essential premise of the House manager's case that Mr. Giuliani's motive in investigating Ukrainian corruption and interference in the 2016 election was an entirely political one, undertaken at the president's direction. But what evidence have the managers actually offered you to support that proposition? On close inspection, it turns out virtually none. They just say it over and over and over. And they offer you another false dichotomy. Either Mr. Giuliani was acting in an official capacity to further the president's foreign policy objectives, or he was acting as the president's personal attorney, in which case they conclude, ipsy dixit, his motive could only be to further the president's political objectives. The House managers then point to various of Mr. Giuliani's public statements in which he is clear and completely transparent about the fact that he is indeed the president's personal attorney. There you have it. Giuliani admits he's acting as the president's personal attorney, and therefore he had to have been acting with a political motive to influence the 2020 election. No other option, right? Wrong. There is, of course, another obvious answer to the question, what motivated Mayor Giuliani to investigate the possible involvement of Ukrainians in the 2016 election? The House managers know what the answer is. It's in plain sight. And Mr. Giuliani has told any number of news outlets exactly when and why he became interested in the issue. It had nothing to do with the 2020 election. Mayor Giuliani began investigating Ukraine corruption and interference in the 2020 election way back in November of 2018, a full 6 months before Vice President Biden announced his candidacy, and 4 months before the release of the Mueller report, when the biggest false conspiracy theory in circulation, that the Trump campaign had colluded with Russia during the 2016 campaign, was still in wide circulation. As The Hill reported, as President Trump's highest-profile defense attorney, the former New York City mayor, often known simply as Rudy, believed the Ukrainians' evidence could assist in his defense against the Russian collusion investigation and former special counsel Robert Mueller's final report. So Giuliani began to check things out in late 2018 and early 2019. The genesis of Mayor Giuliani's investigation was also reported by numerous other media outlets, including CNN, which related that Giuliani's role in Ukraine can be traced back to November 2018, when he was contacted by someone he describes as a well-known investigator. The Washington Post and many other news outlets reported the same information. So yes, Mayor Giuliani was President Trump's personal attorney, but he was not on a political errand. As he has stated repeatedly and publicly, he was doing what good defense attorneys do. He was following a lead from a well-known private investigator. He was gathering evidence regarding Ukrainian election interference to defend his client against the false allegations being investigated by Special Counsel Mueller. But the House managers didn't even allude to that possibility. Instead, they just repeated their mantra that Giuliani's motive was purely political. And that speaks volumes about the bias with which they have approached their mission. The bottom line is, Mr. Giuliani defended President Trump vigorously, relentlessly, and publicly throughout the Mueller investigation, and in the nonstop congressional investigations that followed, including the attempted Mueller redo by the House Judiciary Committee, which the managers would apparently like to sneak in the back door here. The House managers may not like his style. You may not like his style. But one might argue that he is everything Clarence Darrow said a defense lawyer must be: outrageous, irreverent, blasphemous, a rogue, a renegade. Fact is, in the end, after a 2-year siege on the presidency, 2 Inspector General reports, and a $32 million special counsel investigation, turns out Rudy was spot on. Seems to me, if we're keeping score on who got it right, on allegations of FISA abuse, egregious misconduct at the highest level of the FBI, alleged collusion between the Trump campaign and Russia, and supposed obstruction of justice in connection with the special counsel investigation, the score is Mayor Giuliani 4, Mr. Schiff 0. But in this trial, in this moment, Mr. Giuliani is just a minor player, that shiny object designed to distract you. Senators, I urge you most respectfully, do not be distracted. Thank you, Mr. Chief Justice. I yield back to Mr. Sekulow.
Mr. Chief Justice, members of the Senate, House managers, we're going to now move to a section dealing with the law. Two issues in particular that my colleague, Pat Philbin, the Deputy White House Counsel, will be addressing. Issues involving due process and issues, specifically legal issues, dealing with the second article of impeachment, obstruction of Congress. So I will yield my time now, Mr. Chief Justice, to Mr. Philbin.
Mr. Chief Justice, Senators, Majority Leader McConnell, Minority Leader Schumer, the other day as we opened our presentation, I touched on two areas, some of the due process violations that characterized the proceedings in the House, and some of the fundamental mischaracterizations and errors that underpin the House Democrats' charge of obstruction. And today I'll complete the presentation on those points to round out some of the fundamentally unfair procedure that was used in the House and its implications for this proceeding before you now, and also address in detail the purported charges of obstruction in the second article of impeachment. On due process, there are three fundamental errors that infected the proceedings in the House. The first is, as I explained on Saturday, the impeachment inquiry was unauthorized and unconstitutional from the beginning. No committee of the House has the power to launch an inquiry under the House's impeachment power unless the House itself has taken a vote to give that authority to a committee. I noted that in cases such as Roomley versus United States and United States versus Watkins, the Supreme Court has set out these principles, general principles derived from the Constitution, which assigns authority to each chamber of the legislative branch, to the House and to the Senate, but not to individual members or to subcommittees. For an authority of the House to be transferred to a committee, the House has to vote on that. The D.C. Circuit has distilled the principles from those cases this way. To issue a valid subpoena, a committee or subcommittee must conform strictly to the resolution establishing its investigatory powers. That was the problem here. There was no such resolution. There was no vote from the House authorizing the issuance of subpoenas under the impeachment power. So this inquiry began with nearly 24 invalid subpoenas. The Speaker had the House proceed on nothing more than a press conference in which she purported to authorize committees to begin an impeachment power. Under the Constitution, she lacked that authority. As the chairman of the House Judiciary Committee during the Nixon impeachment inquiry pointed out, Peter Rodino explained that such a resolution from the House has always been passed by the House. It is a necessary step if we are to meet our obligations. So we began this process with unauthorized subpoenas that impose no compulsion on the executive branch to respond with documents or witnesses. And I'll be coming back to that point, that threshold foundational point, when we get to the obstruction charge. The second fundamental due process error is that the House Democrats denied the president basic due process required by the Constitution and by fundamental principles of fairness in the procedures that they used for the hearings. And I'm not going to go back in detail over those. As we heard from Judge Starr, the House Democrats essentially abandoned the principles that have governed impeachment inquiries in the House for over 150 years. And I'll touch on just a few points and respond to a couple of points that the House managers have made. The first is that in denying due process rights, the House proceedings were a huge reversal from the positions House Democrats themselves have taken in the recent past, particularly in the Clinton impeachment proceeding. And I believe we have Manager Nadler's description of what was required. Manager Nadler was explaining that due process requires at a minimum notice of the charges against you the right to be represented by counsel, the right to cross-examine witnesses against you, and the right to present evidence. All of those rights were denied to the president. Now, one of the responses that the managers have made to the defect that we pointed out in the secret proceedings where Manager Schiff began these hearings in the basement bunker is that, well, that was really just best investigative practice. They were operating like a grand jury. Don't be fooled by that. Those hearings operated nothing like a grand jury. A grand jury has secrecy primarily for two reasons: to protect the direction of the investigation so others won't know what witnesses are being called in and what they're saying, to keep that secret for the prosecutor to be able to keep developing the evidence, and to protect the accused, because the accused might not ever be indicted. In this case, all of that information was made public every day. The House Democrats destroyed any analogy, any legitimate analogy to a grand jury, because that was all public. They made no secret that the president was the target. They issued vile calumnies about him every day. And they didn't keep the direction of their investigation secret. Their witness lists were published daily. The direction of the investigation was open, and the testimony that took place was selectively leaked to a compliant media to establish a false narrative about the president. If that sort of conduct had occurred in a real grand jury, that would have been a criminal violation. Prosecutors can't do that. Under Rule 6E of the federal criminal rules, it's a criminal offense to be leaking what takes place in a grand jury. And also, the grand jury explanation provides no rationale whatsoever for the second round of hearings. Remember, after the basement bunker, after the secret hearings where the testimony was pre-screened, then the same witnesses who had already been deposed were put on in a public hearing where the president was still excluded. Ask yourself, what was the reason for that? In every prior presidential impeachment in the modern era where there have been public hearings, the president has been represented by counsel and could cross-examine witnesses. Why did there have to be public televised hearings where the president was excluded? That was nothing more than a show trial. Now, I also addressed the other day the House manager's contention that they had offered the president due process, that when things reached the third round of hearings in front of the House Judiciary Committee, that Manager Nadler offered the president due process, and I explained why that was illusory. There was no genuine offer there, because before any hearings began, other than the law professor's seminar on December 4th, the Speaker had already determined the outcome, already said there were going to be articles of impeachment, and the Judiciary Committee had informed the counsel's office that they had no plans to call any fact witnesses or have any factual hearings whatsoever. It was all done, it was locked in, it was baked. And there was something else hanging over that when they had offered, purportedly, to allow the president some due process rights. And that was a special provision in the rules for the House Judiciary Committee proceedings, also unprecedented, that allowed the House Judiciary Committee to deny the president any due process rights at all if he continued to refuse to turn over documents or not allow witnesses to testify. So that if the president didn't give up his privileges and immunities that he had been asserting over executive branch confidentiality interests, if he didn't comply with what the House Democrats wanted, then it was up to Chairman Nadler potentially to say no rights at all. And there's a term for that in the law. It's called an unconstitutional condition. You can't condition someone's exercise of some rights on their surrendering other constitutional rights. You can't say, we'll let you have due process in this way if you waive your constitutional privileges on another issue. The last point I'll make about due process is this. It's important to remember that due process is enshrined in the Bill of Rights for a reason. It's not that process is just an end in itself. Instead, it's a deep-seated belief in our legal tradition that fair process is essential for accurate decision-making. Cross-examination of witnesses in particular is one of the most important procedural protections for any American. The Supreme Court has explained that for over 250 years, our legal tradition has recognized cross-examination as the greatest legal engine ever discovered for the discovery, ever invented for the discovery of truth. So why did House Democrats jettison every precedent and every principle of due process in the way they devised these hearing procedures? Why did they devise a process that kept the president locked out of any hearings for 71 of the 78 days of the so-called investigation? I would submit because the process was never about finding the truth. The process was about achieving a predetermined outcome on a timetable and having it done by Christmas. And that is what they achieved. Now, the third fundamental due process error is that the whole foundation of these proceedings was also tainted beyond repair because an interested fact witness supervised and limited the course of the factual discovery, the course of the hearings. And I explained the other day that Manager Schiff had a reason, potentially, because of his office's contact with the so-called whistleblower and what was discussed and how the complaint was framed, which all remained secret, to limit inquiry into that, which is relevant. The whistleblower began this whole process, his bias, his motive, why he was doing it, what his sources were. That's relevant to understand what generated this whole process. But there was no inquiry into that. So what conclusion does this all lead to, all of these due process errors that have infected the proceeding up to now? I think it's important to recognize the right conclusion is not that this body, this chamber, should try to redo everything, to start bringing in new evidence, bring in witnesses because the president wasn't allowed witnesses below, and redoing the whole process. And that's for a couple of reasons. One is, first, as my colleagues have demonstrated, despite the one-sided unfair process in the House, the record that the House Democrats collected through that process already shows that the president did nothing wrong. It already exonerates the president. But the second and more important reason is because of the institutional implications it would have for this chamber. Whatever precedent is set, whatever this body accepts now as a permissible way to bring an impeachment proceeding and to bring it to this chamber, becomes the new normal. And if the new normal is going to be that there can be an impeachment proceeding in the House that violates due process, that doesn't provide the president or another official being impeached due process rights, that fails to conduct a thorough investigation, that doesn't come here with the facts established, that then this body should become the investigatory body and start redoing what the House didn't do and finding new witnesses and doing things over and getting new evidence, then that's going to be the new normal. And that will be the way that this chamber has to function. And there'll be a lot more impeachments coming because it's a lot easier to do an impeachment if you don't have to follow due process and can come here and expect the Senate to do the work that the House didn't do. I would submit that is not the constitutional function of this chamber sitting as a court of impeachment. And it should not put, this chamber should not put its imprimatur on a process in the House that would force this chamber to take on that role. Now I'll move on to the charge of obstruction in the second article of impeachment. Accepting that article of impeachment would fundamentally damage the separation of powers under the Constitution by permanently altering the relationship between the executive and the legislative branches. In the second article, House Democrats are trying to impeach the president for resisting legally defective demands for information by asserting established legal defenses and immunities based on legal advice from the Department of Justice's Office of Legal Counsel. In essence, the approach here is that House Democrats are saying, when we demand documents, the executive branch must comply immediately. Any assertions of privilege or defenses to our subpoenas are further evidence of obstruction. We don't have to go through the constitutionally mandated accommodations process to work out an acceptable solution with the executive branch. We don't have to go to the courts to establish the validity of our subpoenas. At one point, Manager Schiff said that anything that makes the House even contemplate litigation is evidence of obstruction. Instead, the House claims they can jump straight to impeachment. What this really means in this case is that they're saying for the president to defend the prerogatives of his office, to defend constitutionally grounded principles of executive branch privileges or immunities, is an impeachable offense. If this chamber accepts that premise, that what has been asserted here constitutes an impeachable offense, it will forever damage the separation of powers. It will undermine the independence of the executive and destroy the balance between the legislative and executive branches that the framers crafted in the Constitution. As Professor Turley testified before the House Judiciary Committee, basing impeachment on this obstruction theory would itself be an abuse of power by Congress. And I'd like to go through that and unpack and explain some of that. And I'll start by outlining what the Trump administration actually did in response to subpoenas, because there are three different actions, three different legally based assertions for resisting different subpoenas that the Trump administration made. And I pointed out on Saturday there has been this constant refrain from the House Democrats that there was just blanket defiance, blanket obstruction, as if it were unexplained obstruction, just we won't cooperate without more. And that's not true. There were very specific legal grounds provided, and each one was supported by an opinion from the Department of Justice's Office of Legal Counsel. So the first is executive branch officials declined to comply with subpoenas that had not been authorized. And that's the point I made at the beginning. There was no vote from the House. Without a vote from the House, the subpoenas that were issued were not authorized. And I pointed out that in an October 18th letter from the White House counsel, that specific ground was explained. And it wasn't just from the White House counsel. There were other letters. On the screen now is an October 15th letter from OMB, which explained, absent a delegation by a House rule or a resolution of the House, none of your committees has been delegated jurisdiction to conduct an investigation pursuant to the impeachment power under Article 1, Section 2 of the Constitution. And the letter went on to explain that legal rationale. Not blanket defiance. There are specific exchanges of letters explaining these legal grounds for resisting. The second ground, the second principle that the Trump administration asserted was that some of these subpoenas purported to require the president's senior advisors, his close advisors, to testify. Following at least 50 years of precedent, the Department of Justice's Office of Legal Counsel advised that 3 senior advisors to the president, the acting White House Chief of Staff, the legal advisor to the National Security Council, and the Deputy National Security Advisor, were absolutely immune from compelled congressional testimony. And based on that advice from the Office of Legal Counsel, the president directed those advisors not to testify. Administrations of both political parties have asserted this immunity since the 1970s. President Obama asserted it as to the Director of Office of Political Strategy and Outreach. President George W. Bush asserted it as to his former counsel and to his White House Chief of Staff. President Clinton asserted it as to 2 of his counsels. President Reagan asserted it as to his counsel, Fred Fielding, and President Nixon asserted it. This is not something that was just made up recently. There is a decades-long history of the Department of Justice providing the opinion that senior advisors to the president are immune from compelled congressional testimony. And it's the same principle that was asserted here. And there are important rationales behind this immunity. One is that the president's most senior advisors are essentially his alter egos. And allowing Congress to subpoena them and compel them to come testify would be tantamount to allowing Congress to subpoena the president and force him to come testify. But that, under the separation of powers, would not be tolerable. Congress could no more do that with the president than the president could force members of Congress to come to the White House and answer to him. There's also a second and important rationale behind this immunity, and that relates to executive privilege. The immunity protects the same interests that underlie executive privilege. The Supreme Court has recognized executive privilege that protects the confidentiality of communications with the president and deliberations within the executive branch is, as the court put it in United States versus Nixon, the privilege is fundamental to the operation of government and inextricably rooted in the separation of powers under the Constitution. So the Supreme Court has recognized the executive needs this privilege to be able to function. It's rooted in the separation of powers. As Attorney General Janet Reno advised President Clinton, the immunity such advisors enjoy from testimonial compulsion by a congressional committee is absolute and may not be overborne by competing congressional interests. So that's Attorney General Reno and President Clinton. This is not a partisan issue. This is not a Republican or Democrat issue. Administrations of both parties assert this principle of immunity for senior advisors. And why does it matter? It matters because the Supreme Court has explained the fundamental principle behind executive privilege is that it's necessary to have confidentiality in communications and deliberations in order to have good and worthwhile deliberations, in order to have people provide their candid advice to the president. Because if they knew what they were going to say was going to be on the front page of the Washington Post the next day or the next week, they wouldn't tell the president what they actually thought. If you want to have good decision-making, there has to be that zone of confidentiality. And this is the way the Supreme Court put it. Quote, human experience teaches that those who expect public dissemination of their remarks may well temper candor with a concern for appearances and for their own interests to the detriment of the decision-making process, end quote. That was also from United States versus Nixon. So those are exactly the interests that are protected by having senior advisors to the president be immune from compelled congressional testimony, because once someone is compelled to sit in the witness seat and start answering questions, it's very hard for them to protect that privilege, to make sure that they don't start revealing something that was discussed. So for a small circle of those close to the president, for the past 40 to 50 years, administrations of both parties have insisted on this principle. Now, the other night, the House managers, when we were here very late last week, they suggested that executive privilege was a distraction, and Manager Nadler called it nonsense. Not at all. It is a principle recognized by the Supreme Court, a constitutional principle grounded in the separation of powers. They also asserted that this immunity has been rejected by every court that has addressed it, as if to make it seem that lots of courts have addressed this. They've all said that this theory just doesn't fly. That's not accurate. That's not true. In fact, in most instances, once the president asserts immunity for a senior advisor, the accommodations process between the executive branch and the legislature begins, and there's usually some compromise to allow perhaps some testimony, not in an open hearing, but in a closed hearing or in a deposition, perhaps to provide some other information instead of live testimony. There's a compromise. But the only two times it's been litigated, district courts, it is true, rejected the immunity. One was in a case involving former counsel to President George W. Bush, Harriet Miers. The district court rejected.
Lester Holt in New York. Let me interrupt briefly to allow some of our stations to return to their regular programming. For the rest of you, our coverage of the Senate impeachment trial continues.
To stay that district court decision, that the appellate court thought there was
Live, local,